This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about title insurance and how a claim could be properly denied by a title insurer if the pleadings and policy wording establish the claim was excluded, and it is in Texas sufficient to reject the claim on that basis alone. And title defects assumed by the insured, established by evidence in the wording of the policy and the pleadings in the complaint against the insured, was sufficient. In 2017, Yale Street Development LLC versus First National Title Insurance Company, the Court of Appeals of Texas on March 13, 2025, was faced with a denied title insurance claim related to a failed construction development in Houston. In 2015, Terry Fisher created 829 Yale Street LLC to construct a mid-rise condominium development at 829 Yale Street in Houston. Fisher obtained loans from Steadfast Funding and D&A Alvarez Group to complete the project. 829 Yale conveyed its title to Jetall Companies, Inc. to avoid litigation which triggered a default on the D&A Alvarez lien. 2017 Yale closed on a new loan in April of 2017, but D&A Alvarez's lien remained in default, causing the new loan to default immediately. In February of 2019, Michelle Fraga sent a claim notice to First National on behalf of 2017 Yale, requesting payment of the policy limit or a defense in the Steadfast case. First National denied the claim, stating that the policy excluded claims of title defects created or assumed by the insured and that no adverse claims cause loss or damage to 2017 Yale. 2017 Yale filed a lawsuit against First National for breach of contract, fraud, and violations of the Texas Insurance Code and Deceptive Trade Practices Act, and the trial court granted summary judgment in favor of First National, and this appeal followed. 2017 Yale raised 11 issues on appeal, and the Court of Appeals reviewed the summary judgment as if it were a new motion. It concluded that the trial court must grant the no evidence summary judgment unless the non-movant, the person on the other side, produces competent summary judgment evidence raising a genuine issue of material fact on the challenged elements. A no evidence summary judgment will be sustained in Texas when there is a complete absence of evidence of a vital fact. Once the movant has met its burden, the burden shifts to the non-movant, who must produce at least a scintilla of evidence, raising a genuine issue of material fact to defeat the no evidence challenge. Because First National's summary judgment motion raised specific no evidence challenges to at least one element of 2017 Yale's claims, the motion was sufficient to shift the burden to 2017 Yale. The Court of Appeals reasoned that in Texas the trial court is required to look only at the pleadings and the insurance policy to determine if the insurance company had a duty to defend. 2017 Yale's no evidence summary judgment response was, the Court of Appeal concluded, deficient because it did not point the trial court to the pleadings and allegations supporting the claim. 2017 Yale failed to defeat the no evidence challenge on the breach of a duty to defend claim. Having overruled 2017 Yale's arguments challenging the trial court's decision, the Court of Appeals affirmed the no evidence summary judgment in favor of First National on all claims, and because it affirmed on no evidence grounds, the Court of Appeals did not need to address 2017 Yale's issues challenging the traditional summary judgment. Overruling all of the appellant's issues necessary to resolve the appeal, the trial court's judgment was affirmed. In my opinion, Texas, unlike most states, limits the interpretation of a liability insurer's duty to defend to a review only of allegations of the complaint and the policy wording. Extrinsic evidence is not allowed to be considered. Since the insurer produced evidence to support its policy defense, 2017 Yale needed to produce something in the complaint or the policy wording that defeated the insurer's motion for summary judgment. Lacking such evidence or policy wording, the motion for summary judgment was granted and affirmed by the Court of Appeals. This video is adapted from my blog, Zelma, on insurance. You can subscribe to the blog by simply clicking on the URL zelma.com/blog. It's free. You can also subscribe to these videos on YouTube and rumble.com. They too are free. And your name and address will not be shared or sold to anyone. If you watch these videos, please click on the like button on YouTube or the thumbs up button on rumble.com, and I'd appreciate it if you tell your friends and colleagues about the blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.